And I'm a law student caseworker at Parkdale Community Legal Services. I'm here today on behalf of the Interclinic Immigration Working Group. And ICIWG is a network of lawyers and community legal workers who work in the community legal system. And they represent immigrants and refugees on a regular basis. So our community clinics represent some of the most vulnerable immigrants and refugees, including women, children, persons with severe mental health or physical disabilities, as well as survivors of torture and trauma. And I'm also here speaking from my experience working with immigrants and refugees, particularly women, as well as a member of the Tamil community, many of whom, like members of my family, came to Canada through refugee resettlement or made a claim for refugee protection from within Canada. So we're presenting today on changes to Section 25, which is the humanitarian and compassionate grounds in the Immigration and Refugee Protection Act, because these changes will drastically impact the communities that we serve. So we believe that the proposed changes to Section 25, and you can find them in Section 25 1.1, 1.2, and 1.3, should be deleted from Bill C-11. So the proposed changes essentially make a person choose between making a refugee claim and a humanitarian and compassionate application. This is because if you make a refugee claim, you're ineligible to make a humanitarian application if your refugee claim is pending and for 1 year after that claim has been refused. So the bill also provides that if you do make a refugee claim and it's refused, and you then make a humanitarian and compassionate application, you can't base your humanitarian and compassionate application on the same dangers and risks that were taken into consideration in your refugee claim. Now, despite sort of the impression that's been given, these changes to the humanitarian process won't save any time or resources for the refugee process, because the humanitarian application, in the current system, it's processed by immigration officers, not by the refugee board. It's usually a paper application and no hearing is involved. And the processing of a humanitarian application does not stop your removal from Canada. So if you have a humanitarian application pending, you can still be removed from Canada after your refugee claim has been refused, unless the federal court determines that you would suffer irreparable harm if you're removed. Now, the federal court doesn't easily make that determination. So it will be impossibly difficult for us in community legal clinics to advise people who have sought refuge in Canada whether they should make a refugee claim or a humanitarian and compassionate application. This is because there's a very large gray area between what constitutes a well-founded fear of persecution, which is the test for convention refugees, or what doesn't meet that stringent and very narrow test, but does constitute very serious hardship, which is the test for successful humanitarian and compassionate application. But if you get accepted as a refugee, that results in much stronger protection. You can't be returned to the country where you fear persecution, and people who are accepted as refugees and their family members are often also exempted from some inadmissibility, such as financial and medical inadmissibility. So deciding whether someone is a refugee in many cases is not a black and white issue. On the same facts, some board members might accept that the person is a refugee, and another board member on the same facts may refuse the person as a refugee. And sometimes they might, in their decision, actually say that they have a good humanitarian claim. Now, we assisted a Roma person from Hungary where this happened. She experienced extreme and a history of attacks by skinheads, and while the board member nevertheless found that there was effective state protection in Hungary, they actually commented that the person had very good humanitarian reasons to remain in Canada. And in that situation, sometimes people also find that what the person experienced is severe discrimination and not persecution, and so it doesn't come in the refugee definition. But with the finding by that board member that the claimant was truthful and had a strong humanitarian case, we filed a humanitarian application and quoted the board member, and the humanitarian application was accepted. But under Bill C-11, you would not be able to base your humanitarian application on the very facts of severe discrimination that the board member described as a strong humanitarian case. So the person would have to decide whether they would take a chance on a refugee claim or base everything on a humanitarian application for which she will not even get a personal interview with the immigration officer making the decision. Also, the humanitarian application is considered to be completely discretionary. So if it's refused, there's no appeal, and getting the federal court to overturn the decision isn't very likely. That's why we're saying that it would be impossible for us to advise a person in this situation whether they should make a refugee claim or a humanitarian application. Furthermore, if something very serious happened to you during the time between when your refugee claim was refused and the time that you're waiting to make a humanitarian application, say you get a severe illness or a life-threatening health condition and for which you're not able to get treatment in your country of origin, you would not be able to make a humanitarian application until the year has passed. So within that time that you're waiting between the refugee decision and when you can make a humanitarian compassionate claim, you could be removed from Canada before the year is up and even die as a result of lack of treatment in your home country. Now, in our experience, lives have been saved because of the ability to make a humanitarian application as soon as the health condition occurred. So another aspect of the proposed changes that's going to seriously impact the communities that we work with is the requirement that a humanitarian application cannot be considered unless the $5.50 processing fee is paid. In working community legal clinics, we have seen many strong humanitarian applications that can't be filed because of the lack of the $5.50 fee, and we have had to do fundraising to help people pay this fee. We have seen desperate people use their food and shelter money in order to pay the fee, and it's particularly difficult for example, women who have fled with children who not only have to raise $5.50, but also have to raise additional fees for their children. Right now, there's a case in the federal court that's considering whether refusal to grant a waiver is a violation of the Canada Charter of Rights, and we believe that a fee waiver is necessary for humanitarian cases, and Section 25(1.1) should be deleted from Bill C-11. So taken together, these changes punish the claimant for having made a claim which has been refused, and this seems to reflect Minister Kenney's harmful suggestion that a refused refugee is necessarily a bogus one, that a person made a false claim knowing that they were not a refugee. In fact, in so many cases, a negative refugee decision does not mean the claim was knowingly false or lacking in merit, but just that it didn't reach the level of severity of what one board member believes is necessary to be a refugee. Negative decisions are often made for reasons having nothing to do with the claimant's credibility. But even if credibility or the claimant's truthfulness is at issue, this may be because the refugee claimant was unable to present their case fully because of the effects of trauma, mental illness, or even poor representation. The idea that some refugee claimants are genuine while others are bogus harms all immigrants and refugees, and I would say people of color in general, by poisoning the public perception of refugees and immigrants as frauds and cheaters, and even turning some immigrants and refugees against each other because some do not want to be associated with bad or bogus refugees. These changes to the humanitarian provisions in Bill C-11 are very drastic and potentially harmful, and people genuinely need protection and fleeing various hardships will not be served by them. The language being used to support such drastic changes is negative and reflects and perpetuates racism and anti-immigrant and xenophobia by suggesting that Canada is being exploited and overrun by phony refugees. The truth is that 40% of refugees that are heard in Canada are accepted by the board, and a high percentage of those that are not accepted, because there is no appeal, are then granted permanent resident status on humanitarian compassionate grounds. In fact, in our office at PCLS, about 90% of the cases we have taken of refugees that have been refused have then been accepted as immigrants on humanitarian grounds. We strongly urge that no restrictions be placed on Section 25(1) as BC-11 proposes. The humanitarian option needs to remain strong as a safeguard for those who do not qualify as refugees, but who would nonetheless suffer disproportionate hardship in return to their country of origin. Also, leaving the humanitarian provisions as they are will not interfere with a more efficient refugee process, but Section 25, if unchanged, will continue to provide the necessary safety net a truly humanitarian case deserves that does not qualify for refugee status.